questions.
You say the government is wrong about the availability of preliminary injunctions. On what do you base that?
So I think that the two reasons I identified, one, it is well settled, and I understood General Sauer to agree today, that universal injunctive relief is appropriate when necessary to provide complete relief to the plaintiffs. That is the case here, and I'm happy to talk about that. But I also, this court has long recognized the availability of universal injunctive relief in extraordinary circumstances where it's justified. I think I would focus particularly on the public interest and equities prongs of the Winter test, and I'm happy to talk about that as well, but I think those are the two reasons the government—
Do you think that if, even if one considers the history not to support you, that the pragmatic considerations and the policy considerations should override that?
So again, I would put us in the complete relief bucket, so like Mr. Feigenbaum, I'll put on my amici hat in answering that question. I understand General Sauer's proposal to be that we channel all of this through Rule 23. I think that is a historical one. It's inconsistent with the Rules Committee's understanding of the rules. Both, if you look at Rule 23, Rule 65, and Rule 71 together, they establish that Rule 23 is not the channeling mechanism that the government's suggesting. I'll start with Rule 71 because it's responsive, Justice DeBarrett, to your question earlier about whether non-parties can enforce orders. Rule 71 explicitly contemplates that and says if a non-party receives relief, they are entitled to enforce it. I'd point also to Rule 65, the preliminary injunction rule. In 2017, the Rules Committee considered a proposal from Professor Bray to amend the rule to prohibit relief to non-parties. The committee rejected that proposal because it found that it ran afoul of the Rules Enabling Committee. And then I'd end by pointing to Rule 23 itself, which says nothing about it being a channeling mechanism. In Principe v. Scarborough, this court said, we don't treat the rules as excluding background equitable practices. And here, Rule 23 doesn't even contemplate preliminary relief. It's focused on permanent injunctive relief, and I think that's because, as we've been discussing, it's very difficult to get class certification in time to have preliminary relief, so you're doing putative class relief, which is the exact same thing as what's happening here.
Well,